Coastal Resources Management Council to order. Today is Tuesday, September 12th, 2023. I'd ask that the record reflect the members of the council that are present, as well as staff members that are here as well. First matter on our agenda would be approval of the minutes of the previous meeting, that being August 28th, 2023. I know Lisa had disseminated them. Any
Approval.
motion made? Is there a second? Motion made and seconded. Any discussion? Hearing none, all in favor, say aye. Aye. Anyone opposed? Motion carries. Those minutes are.
I just want to know, I was not present at that meeting, but I did read the minutes.
All right. Thank you. Subcommittee reports or staff reports. Mr. Willis.
There are no subcommittee reports tonight, Mr. Chair, but I do have a couple of items to alert you all to in a staff report. So I've talked about this at the last council meeting, probably a couple council meetings, where the legislature passed the Shoreline Lateral Access Act back in June. It tasked the CRMC, DEM, and the Attorney General with a lot of outreach and education efforts. One of those I want to alert you to tonight is happening on Thursday, September 21st at 5 o'clock down at East Beach in Charlestown, where the staff, CRMC, are bringing the parties together and the public that wants to attend and walk the shore to further demonstrate the requirements, further demonstrate the allowances of the Shoreline Lateral Access Act and what you, as a public member, should and should not do, educate the private property owners on what you should and shouldn't do, and just try to educate as many people as possible with these in the field events to help further our educational efforts in that matter. So we will also send you a reminder email, excuse me, but it's this Thursday, September 20, or next Thursday, September 21st, 5 o'clock down at East Beach in Charleston. At the last meeting of the council back in August, you all, based on staff's recommendation, a lot of discussion, public input from all parties, concurred with the Sunrise Federal Consistency recommendation, and we issued that concurrence officially to NOAA, National Oceanic Administration, and BOEM, Bureau of Ocean Energy Management, and all parties that were subscribed to that notification. So that particular project has gone through officially the notification process to the federal government. And if you'll remember, it resulted in a number of turbine positions being eliminated, not being used for the project. 3 of those turbine positions being permanently eliminated from use in any future project that might occur out there. As well as a number of other mitigatory measures, and almost $18 million in compensation to the Fishermen's Viability Trust, which was a side agreement because it's not part of any federal consistency review where we can look at compensatory measures. However, the developer did and will be forwarding that almost $18 million to the fishermen's in the form of their Fishermen's Viability Trust. And then lastly, in relation to that, you've all had an opportunity, I'm sure, to read in the newspapers and other media that the Fishermen's Advisory Board, which is an advising board to the agency on all these renewable energy projects in the offshore environment, have resigned. In large part because they do not believe that their voice is being heard in these mitigatory discussions with the developer and the agency in our review of those projects relative to the federal consistency allowances of our enforceable policies. And this was the 3rd project that the FAB has been involved in literally the last 18 to 24 months. They were involved in the very first project got approved, Vineyard Wind, back in 1819. So in each particular review, they were more and more frustrated, in my opinion, and that frustration level resulted in that resignation of all the members to the FAB. We as staff have been in constant contact with our federal partner on how that would affect our federal consistency reviews. We have gotten a lot of information on that, in terms of what the federal requirements are for federal consistency reviews under the CZMA, which is the Coastal Zone Management Act at the federal level. Our reviews are not stopped. The clock has not stopped in that fashion. We are continuing our reviews and will have to continue our reviews underneath the time period and the allowances of that federal consistency clock, if you will. And we will be bringing recommendations to you all for 2 more projects that we've had under review for well over a year now. And that's the New England Wind project and the South Coast project. New England Wind being within our geographic location description, South Coast, which is outside of our geographic location description. So we won't be looking at the farm itself, but its export cable to land cuts through the GLD. So we can look at the export cable as it does there under the federal consistency provisions. So those projects are still under review by staff. We will be bringing them in front of you by the end of this year. You'll see one in October. You'll see another probably around Thanksgiving. Those projects are not affected. We have some other federal consistency reviews coming up in the future, the near future, probably next calendar year. Those projects and the reviews under the CZMA will not be affected at all either. So more on that as we go along, but I just wanted to close the loop on the fact that the FAB resignation is unfortunate. The staff, the agency in general, still would like to work with the members of the fishing community to become part of that advisory board, if you will, to the agency and these renewable energy projects. And we will work to try to get that done. But as of right now, we do not have a FAB, but it does not affect the review process.
Anything further?
Thank you. No, Mr. Chair.
Okay, thank you. All right, brings us to our agenda for this evening. We're going to jump to the second one because we can address that one. Is that?
Oh, sure.
All right, so it's 2023-01-019 East Meadow LLC. Is anyone here on that matter?
Mr. Chair.
All right, Mr. Willis.
Mr.
please.
Chair, if I may, there should not be anyone here. We put out a continuance notice on that matter. This matter will be brought back to the council to be heard, probably if not at the next agenda meeting, then the one after that or shortly thereafter. This matter is being continued in large part because the neighbor has asked to employ legal counsel to see what potential matters that they can look at on this application relative to the impact, the potential impacts to their property.
Is staff satisfied with the explanation given for the request?
We are, Mr. Chair. The notice went out in a timely fashion, but in deference to the objector, the neighbor, we felt that their request to engage legal counsel was a satisfactory reason to do so.
Okay, with that, entertain a motion to grant the continuance as requested. Someone want to make a motion? Mr. Flynn has made the motion. Is there a second?
Second.
Mr. Gomez has seconded it. So motion made and seconded. Any discussion? If none, I'll poll the council. Ms. Hall?
Aye.
Mr. Gagnon?
Aye.
Mr. Flynn?
Yes.
Mr. Izzy?
Aye.
Mr. Gomez?
Aye.
I too, Raymond Coy, vote aye. So that matter will be continued. Brings us to 2023-03-09 Interstate Navigation Company. Are the parties ready on that? If so, please come forward. That's an application to install a new 8-pile timber dolphin 33 feet seaward of the existing fixed pier located between the 2 ferry berths and 3 feet landward of the boundary of the federal project. Parentheses, the 15-foot channel, comma, basin and anchorage that lies within the confines of Old Harbor, close parentheses, located at plat 6, lot 150, semicolon 150 Water Street, New Shoreham, Rhode Island.
Rich.
Mr. Lucia has this one for us, please.
The block on the ferry terminal has existed for numerous years in different configurations for some time. This project before the council is going to be considered a category B application because it's not considered maintenance because it's a new structure in tidal waters. As stated by the applicant's consultant, the new dolphins will improve efficiency and safety of the ferry operations. One of the benefits of the project is the reduction of the use of the engines while landing and unloading, which will also reduce disturbance to the harbor bottom. The dolphins will also reduce loads onto the fixed pier. It is staff's opinion that the project meets the policies and goals of the Type 5 waters, which is recreational and commercial harbor. The staff has no objections to the project, and standard stipulations will be paid for this ascent if it is approved by the council.
Any questions of Mr. Lucia by council members? And if the applicants can just identify themselves for the record, please.
Gus Cruz Camp, Harbor Engineer Consultant,
Can you spell your last name, please?
KREUZKAMP.
Thank you.
Joshua Linda, Vice President of Interstate Navigation.
Christian Myers, and I'm the port captain for Interstate Navigation, MYERS.
Do you wish to swear them in if they give any testimony or comments?
Well, I'll swear all of you in at the same time. If you all please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And would you each, starting with you, spell and state and spell your name for the record?
Christian, CHRISTIAN, Myers, MYERS.
Thank you.
Joshua, JOSHUA, Linda, LINDA.
Thank you.
Gus GUS Cruz Camp, KREUZKAMP.
Thank you.
Thank you. Gentlemen, you've heard an explanation by Mr. Lucia. What do you wish to add to that?
Nothing. It's perfect.
Any questions of the applicants by council members? Anything to add, Mr. Lucia? Is the council ready for a motion based upon the representations made by Mr. Lucia and the record contained in the application?
I will move the application be approved based on the presentation by staff, the findings of fact. And I didn't see any objections contained within the staff report. So based on no objections, I think that this ought to be approved.
Second.
With the usual stipulation.
I'm sorry.
No, that's okay.
Yes, I even said that.
As he said, yeah. Okay. Motion made by Mr. Gomez, seconded by Mr. Gagnon. Any discussion? Hearing none. We will now pull the council. Ms. Hall.
Aye.
Mr. Gagnon.
Aye.
Mr. Flynn.
Aye.
Mr. Izzy.
Aye.
Mr. Gomez.
Aye.
I too, Raymond Coyer vote aye, so the application is approved. Thank you, gentlemen.
Thank you.
Thank you. Thank you, Rich.
No.
Next matter, Edward Troiano, 2017-05-006. It's an application for 1/2 acre oyster aquaculture site using submerged long line system located in Ninth Point of Upper Narragansett Bay, Barrington, Rhode Island. And is the applicant and his counsel present?
Yes.
Good evening.
Good evening.
Good evening.
Attorney Shikatra, we could just identify yourself for the record.
Yes, Mr. Chairman. Good evening. Good evening to members of the council. My name is Mary Shikarchi, and I represent the applicant for this evening.
Thank you. And next to you is Mr. Troiano, I presume.
Correct.
Okay, thank you. I'm gonna ask Attorney Hartman to update the council as to the posture of the matter here this evening, and then ask Mr. Willis to comment as well before we get into your presentation. So with that, Attorney Hartman.
Thank you, Mr. Chair. So the matter tonight comes before the council, kind of an interesting posture in that it was before the council in 2018, February 13th, 2018. And at that time, there was a full hearing and vote on the application. It was a 4-4 typo ending in resulting in a denial of the application. Subsequently, Mr. Troiano appealed the denial to the Superior Court on the grounds that the council did not consider certain supplemental evidence that was part of the record, and also that the council did not provide Mr. Troiano with an adequate opportunity to ask questions of each objector that spoke before the council. The case went up to Superior Court, and in Superior Court, Judge Kehoe determined that Mr. Troiano was correct on those grounds for appeal. And she subsequently remanded the case back to the council for a de novo review, meaning to review the application anew. And she specifically indicated that the council has to consider the 54-page supplement that Mr. Troiano had provided, as well as provide an opportunity for the council of Troiano to question objectors to the application. And with that, I'll hand it over to Mr. Willis if he has any.
I don't have much more to add. Thank you. Other than the matter here in the agenda package is as it was on the original hearing date. We did not supplement it on the staff level. We felt that there was no new additional information that should be supplemented in a staff report. However, we have our aquaculture coordinator here, Ben Getch, to answer any questions of the council or however the questions might come through the chair to Ben in this matter.
Thank you. Any questions of the council or by the council to Attorney Hartman, Mr. Willis, or Mr. Getch before Ms. Hall?
So to that point of no additional review by staff because of your decision that it didn't merit, no new information was submitted. I was wondering if the staff in reviewing this anew is what Attorney Hartman said, that your interpretation of Judge Kehoe's remand back to the agency for a de novo review of the application.
The council's de novo review of the application.
In your estimation, in the last 5.5 to 6 years, have all of the conditions at the site relative to the staff's expertise and review, have all of those conditions remained the same?
There has been no subsequent visit by staff to this site. There's no.
I'm sorry?
Staff has not visited this site since the initial review by Dave Butel several years ago. To my knowledge, there are no changes, but it's possible there have been.
Because some of the issues raised in the original staff report specifically leaned on the abundance and the shellfish surveys that were completed some time ago. And this 2017 site assessment, can you imagine that those surveys might be different relative to shellfish present in this area in terms of a greater abundance or a less abundance, for example, of quahogs?
Yeah, it's entirely within the realm of possibility. Quahog populations have been shown to fluctuate sometimes dramatically throughout the bay, depending on conditions. As you can see some of the dredge survey material provided by the applicant from DEM records. Some areas can see quite a bit of fluctuation.
So would that change the staff's opinion in terms of standing with the original Dave Butel opinion? Would that change the opinion of the staff at this time in any way?
The shellfish survey is conducted not by any regulation. There is no regulation that speaks to a shellfish density that is required for an aquaculture site to be considered. The practice of shellfish surveying has been a historical one, very long-standing, that was been developed mostly through working with the shell fishermen through the Shellfish Advisory Panel, the Subcommittee of the Marine Fisheries Council. So as you know, the CRMC is required to consider the opinion of the Marine Fisheries Council pursuant to 2010-5, the Rhode Island General Laws. That recommendation is usually not given before a shellfish survey has been done, and that is usually material provided to the panel and to the Marine Fishery Council for their benefit in rendering their recommendation.
Right, but is that relevant to the issue of use, conflict of use? I understand what you're saying with respect to the positionality of the Marine Fisheries Council and their advisory capacity, but does that could it possibly change the staff's perspective relative to use as the staff is bound to look at in its own regulations?
Without having done a follow-up review, which would require starting back to a preliminary determination, working with shell fishermen through a full application, 30-day public notice reviewed by the Marine Fishery Council and the DEM, I cannot really opine on that at this point. I was not the staff member and during the initial review of this application.
But I just
Mrs. Gomez, please.
ask a legal question. What are we able to do with this situation? Can we just revoke this after providing some review here, or do we have to start at the beginning again and go through the whole procedure?
Well, the court specifically stated that CRMC shall review plaintiff's application de novo and conduct a new properly advertised public hearing in accordance with this decision. So to me, that means that the council's reviewing the application as it was submitted in 2018.
At this point?
At this point.
Okay. I do have a couple of questions. One was, do you know if there was any vegetation in that area submerged?
No, the previous surveys, the previous shellfish survey also looks for submerged aquatic vegetation. None was found at that time. Also, since the beginning of eelgrass surveys that are done statewide, this area has never been shown to be a eelgrass.
And the other question, I kind of went through, did go through this, and could you tell me what the stipulations were?
Sure. There were 4 stipulations recommended along with this staff report. Dated December 21, 2017 by Dave Butel. The first stipulation is that no expansion would be allowed for this site. That, my understanding was due, the logic behind that anyways, was that this area nearby is used by commercial shell fishermen, and that the site should remain small in order not to become more of a potential obstacle to that use in the vicinity. The other stipulation in the report noted on page 119 is that the gear should be at least 1.5 feet below mean low water. This is a little further than the plans submitted, and this is due to the winter tides, mean low tides in particular, which can be greater than 1 foot below mean water. The plans as proposed propose the baskets to be just 1 foot below mean water. So Dave Butel thought 1.5 feet would be more prudent to ensure that the gear remained submerged at all times. that was a consideration in the review of this application, as it also relates to the minimization of scenic impact. I also believe, in my own opinion, that it would serve the gear better in its safety and security, not to be exposed to the air and the winds. There was also a stipulation, which is attachment A19 of the original staff report, page 139 of this package. And that is from the DEM Office of Water Resources. And they have a few stipulations there requested to be included in the permit. Dave Utel agreed they were reasonable. And those stipulations relate to working the site during the conditionally closed periods. This application is located in conditional area A, which is an area subject to closure based on rainfall. So off the top of my head, I think it's 1.5 inches of rain in 24 hours necessitates a 7-day closure. The provisions that have been developed over time between DEM, Department of Health, and CRMC when it comes to aquaculture in conditional waters is that the work should not have the site should not be visited except for specific activities. And the permission to access during enclosure is required to be requested from CRMC aquaculture coordinator and also in some circumstances DEM enforcement. We do not have any aquaculture. Well, there's one farm in the entire state that was permitted originally in conditional waters. That is on the opposite side of Area A, off the coast of Warwick. There are at least 2 other farms that are in conditional areas, but they were permitted in approved waters originally, were downgraded into conditional waters through no fault of their own, but the degradation of water quality, which forced DEM to make a classification change. Other than that, there are several farms that are in a seasonally closed area, also considered conditional, but it's a seasonal condition, not a rainfall condition. In Trim's Pond, Block Island.
That was one of maybe my follow-ups. What's the winter use of this? Is the gear going to be brought ashore or is it going to remain in place?
My understanding from reviewing the record in the application, the staff report, is this would be a year-round operation.
And I don't know if this is a fair question, but the council will let me know whether it is or not, I guess. Would you, at this point, recommend approval of this? Is that a fair question? You're thinking?
I think that we have to stick to the 2018 report as it stands.
But the end play here is whether we override the previous decision or not.
So
correct?
So we should be hearing the 2018 application, but we will be hearing any testimony from Mr. Troiano as well as the objectors. So I think that it's fair that our staff can also provide additional supplemental
recommendations.
at this point.
Okay, and is it fair at this time to ask that, or should I wait?
Yes.
It is fair. At this point, would you recommend? Now, Dave Patel has recommended approval, I believe, right? We've been through the conditions of what stipulations, so I would just like your opinion.
Yes. In abundance of caution, I would highlight Dave Butel's specific recommendation. Staff recommends approval while acknowledging the concerns of the objectors. That, I think, fairly sums it up. There is nothing in the regulations that would precipitate a recommendation of denial. There are certain policies that do not encourage aquaculture in conditional waters currently. Those have come about largely through work through the basin. But I understand the logic of the objectors, as did Dave Butel. And I think he outlines that pretty fairly in his report.
Thank you. Any other questions before we hear from the applicant? Ms. Hall?
Attorney Hartman, I just would like to get a clarification from you.
Yes.
The Superior Court decision and the remand refers to the council and CRMC interchangeably throughout the decision.
Mhm.
Our own regulations do the same. In management procedure regulations refers to council as any of the assorted subparts of the council, the staff, the body seated here. This court did not clarify that. It uses the term council and CRMC interchangeably. The mandate is CRMC shall review the plaintiff's application de novo. And then it goes on to say, conduct a new and properly advertised hearing, and review the complete application materials. And I just want to be clear that you're advising that it is your opinion that this Superior Court remand is suggesting that we only go back and look at the 2018 application and not review their application de novo as an application that would apply current rules and regulations. In past decisions of the court to this agency that had sent the matter back, at times the court, and obviously different judges have clarified, apply the old rules, go back in time. This does not have that language. So I just want to be clear as far as what you're advising, that de novo, your interpretation is just go back and look at the old review and the old staff report and not current conditions and not current surveys and not current water classifications that may have changed as we've heard in that time. We're to ignore that.
Yes, so it's very typical when on remands that you review the application as it was before the council, when it came before the council. And I think that the language in the decision really focuses on the public hearing aspect of this.
Well, it says de novo.
Yes, but they say it, so this is the final sentence from the court. The CRMC shall review, and I've already read this, but the CRMC shall review plaintiff's application de novo and conduct a new properly advertised public hearing in accordance with this decision, including providing plaintiff with an opportunity for reasonable cross-examination in consideration of the complete application materials. Legal counsel's opinion is that provides that the emphasis the court is placing is on this hearing right here tonight, providing the applicant an opportunity to question the objectors and providing the council an opportunity to review the supplemental materials.
So with that in mind, are we to consider testimony we may hear tonight that relates to current conditions? Are we to consider that, or should we not be considering that in our consideration and deliberations? Because if we're not to consider it, then would it be reasonable to guide public comment to not include current conditions if to follow your legal advice to the council?
You can consider the testimony of the objectors and the applicant, but the materials themselves have to remain the same.
But the testimony on new conditions then is irrelevant. If we hear testimony on new conditions at the site relative to use or surveys or the presence of a greater abundance, for example, we're to not consider that. It's not relevant to our deliberations.
You can consider it, but the status which this is here tonight is for this hearing and not anything else.
But if we consider it, we're only hearing from the public. We're not hearing about that from our own staff. So how can we consider that? We're not hearing the staff side of that information. So can we consider testimony we may hear about new information when we don't have the benefit of the staff's analysis or review of that information, as we normally would as this body of, we're informed by the staff.
Absolutely. So it goes to the weight of the evidence.
Can I ask a question? So I'm following up on Ms. Hall's initial point about the presence of quahogs and the density of quahogs. It was one of the points that was mentioned in the staff's original report from 2017. That I'm sure was consideration in the recommendation for approval from the staff. Now, the council didn't go along with that. And I'm having a hard time understanding. And maybe we'll get some information from the applicant or from objectors. 6 years have passed since then. Things could have changed quite a bit. And if this was now a highly productive area, that might affect the decision. But I think what you're saying is that even if we hear information along those lines, I guess I'm hearing we can consider it, but I guess I'm not really sure what you're saying is that if we're only looking at the application from 2017, that's easier, I guess. But if we are going to hear things, and we probably will, about more recent information, I'm not sure how we integrate that with a record that goes back to an application filed in 2017, decision rendered in 2018. I'm just having a hard time with it, and I'm not an attorney, so I'll plead the fifth, I guess. But please.
Kevin, you're not an attorney, but you've been in the position more than likely in your previous positions, especially your municipal positions, of, I think, acting on a remand from Superior Court. And a remand from Superior Court comes with what's called a mandate. And that's what Mark and that's what Catherine were referring to when they said, you know, the Superior Court said, and they were very particular about the language that the Superior Court Judge Keogh used. And we're required to follow the mandate of the Superior Court. That's what we're instructed to do. So when the court said it goes back for a de novo hearing, it means the hearing that should have taken place back in 2018, 2019. So we're actually in a time capsule and going back to that.
That was kicked back for procedural matter.
For procedural matter, yes, exactly. It wasn't overturned. It wasn't overruled. She said, well, it wasn't handled exactly as it should have been. So you're going to go back and do it again, as if you were doing it at that original hearing. So, I mean, without, you know, trying to figure out how many Clevelands can dance on the head of a pin, no, we can't look forward from that 2018 hearing. When was the hearing?
2018.
2018 hearing. So we're in 2018. We're hearing the evidence, irrespective of, you know, what's happened since then. We have the staff report to rely on. We have the expert reports to rely on, and whatever anyone has to say about the status of the area as of that time is relevant to our consideration. But what's there now is not relevant to our consideration. And that's, you know, whether we would like it to be or not, we have a mandate from the Superior Court that we are obligated to follow. And the reason that I brought up your past is because this happens all the time in zoning and subdivision cases. They say, no, the procedure wasn't right, so go back.
No, we never have that.
Not grants,
They never have.
no. Go back and have another hearing based on the evidence that was available at the original hearing, not what's there now.
That's easier to understand.
Okay.
Thank you.
That's all. Thank you,
With
Steve.
all due respect to that opinion, it isn't what the language is. You stated that, the Superior Court said, go back and do the hearing. What it actually said was go back and review the application. That's different than go back and hold the hearing. In environmental matters, it's not always go back and put blinders on when they tell you to go back and review the application. So that's why I'm seeking the clarification, because the language isn't go back and do the hearing. It's go back and review the application de novo. And I understand Attorney Hartman is advising that it's his opinion, and clearly, Mr. Izzy, you agree that that is the case. It's not necessarily up to us to agree. It's up to us to just be advised by our counsel attorney. But the language isn't clear. The language doesn't say go back and do the hearing. It says go back and review the application. So I share Mr. Flynn's concern about just the standard of it goes to the weight of the evidence. That is very unclear, because in the packet itself is a recent letter that bears very directly on the new base amp, the new conditions, new abundance, different situations. So that's a piece of evidence that you're advising us to perhaps not regard as highly, or not regard at all, or give very little weight to, because it is. I didn't know if you could hear me while you were speaking, because it goes directly to current conditions. So just to be clear, your advice is that we go forward. We only think about the review as was conducted in 2017. If there's current testimony on current conditions, it's relevant perhaps, but some less weight is to be given to it. And we won't hear from the staff about anything current to countermand whatever we may hear from the public. Is that how we go forward? Just so I'm clear. Okay, thank you.
Thank you. Attorney Shikachi, would you like to add anything to what you've heard so far as our review? If not, you can go right into your presentation, or if you do, because I know you were involved with the matters at the court.
Yes, I was involved in matters of the court. I would agree with counsel for the legal counsel for the council. Clarify that.
Okay, thank you. And with that,
I'd like to call the first witness and only witness I have this evening, which is Mr. Toronto. He is the applicant, and I'd like him to just explain the proposal that's before the council.
Mr. Toronto, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Would you please state and spell your name for the record?
Edward Maiano, last name is T as in Tom, Roiano.
Thank you, sir.
Thank you.
Mr. Toronto, could you just give a background, some information about your background as it relates to aquaculture?
Sure. So when I first thought of this venture, back many years ago now, I think in 2012, I took an initial course at the university, Roger Williams University, with Professor Dale Levitt in aquaculture. That was a several weeks long course, and that kind of started me getting educated with the various matters involved in having a farm and applying for a farm, etc. Generally speaking, I have I grew up on shore of the Long Island Sound when I was a kid. I've been involved in various recreational fishing activities my entire life, since I was 12 years old. Those included lobstering, plant, cohogging, well pots, etc. In the past few years, I've also sat on the Shellfish Advisory Panel, along with some of the gentlemen behind me, that advises DEM. I also sat on this council's SAMP or aquaculture in Narragansett Bay. And I also have, I am a licensed charter boat captain by the United States Coast Guard.
Thank you. And can you just explain your application that's before the council this evening?
Sure. So this is not my first application. My initial application was for preliminary determination for a location in Adams Point section of Barrington. I worked with Dave Butel with that preliminary determination. And once that went forward and we got feedback and Dave did a survey in that area. Dave went out, he got his bull rig and came up with a, you're gonna hear this term a lot, density of 5 cohogs per square meter in that area. Now, Dave explained to me that there was an agreed upon standard that both CRMC, DEM, Shellfish Advisory Panel, and most of the folks involved in the decision-making process agree on that 3 cohogs per square meter is considered commercially viable. So with feedback received from some of the commercial shell fishermen who objected based upon that density, I decided not to pursue that application, and instead I asked Dave to put me in touch, requested him if he could put me in touch with someone from the cohog industry that could advise where an alternative location might be in the general Upper Bay area. Dave did that. He provided me with the name of Mr. McGivney. I attempted to contact Mr. McGivney, but did not receive a response. I then went to Connor McManus, who was with DEM at the time. I asked if he could assist me with perhaps getting in touch with Mr. McGivney or someone from the Shellfish Advisory Panel to discuss the matter.
Mr. McConnell, was that his name? What is his role? McManus, sorry. What is his role at DEM?
At the time, I'm not sure what his exact title was, but he represented the fisheries department. That was where he was from.
Thank you.
And he sat on the Shellfish Advisory Panel with us at that point in time. Again, Mr. McManus did attempt to arrange a meeting. However, he received feedback that there was a general objection to discussing any aquaculture in the Upper Bay on the part of Mr. McGivney's organization. So I then went back to Dave and asked him if there was anyone outside of that organization involved in shell fishing that I could speak with. And he got me in touch with some individuals from the East Bay shell fishermen, who in turn gave me advice that this current area off of Naya Point would be an area to pursue because of the historical lack of shellfish in this particular area. Not in the Upper Bay in general, but in this particular area. And those recommendations, both the correspondence with East Bay shell fishermen and my attempts to speak with the Shell Fishermen's Association are documented in Dave Butel's preliminary determination report on Adams Point, which has been submitted as an exhibit to the council. And I believe, Mary, you have that on the overhead.
In I don't know if this will show up, but this is
Yeah, so.
those reports here?
I can read it for the council. They all have a copy of it, right?
They should,
As
yes,
an
I don't think
exhibit.
that one's here. Yes,
So the relevant portions of Dave's preliminary determination report as in regard to my initial
So if
application.
if I just may,
Sure.
this is an exhibit that was submitted in with your application. And it's dated on January 31st, 2017, correct?
Yes.
Thank you. Yeah, if you could just read it into the record, please.
So the cover letter says in part, the meeting in Barrington was very positive, but subsequent investigation corresponded indicated that the Smith Cove site is not appropriate. The East Bay shell fishermen have suggested pursuing a site near Nahant Point. That was the cover letter. On page 2 of Dave's preliminary determination report, he documents that the applicant communicated with East Bay shell fishermen in a location near Nahant Point in front of the golf course was suggested. CRMC staff attempted to review this location with the West Bay shell fishermen, but was unsuccessful. So, following those recommendations, and coordinating with Mr. Butel, I did do another preliminary determination for this particular area, which is a conditional area A. And subsequent to that, Dave did his site survey, which came up, and there is a copy of that in his report where he documents the survey. On the entire half acre that Dave personally sampled, he found 2 quahogs, which came out to a density of 0.27 quahogs per square meter. Again, the relevant standard as expressed to me was 3 quahogs per square meter.
And I'm gonna hand you an exhibit that's already part, I believe, of the application. And that's Dave's aquaculture site evaluation stating that. Is that correct? Is that the document? And this is part of, this was submitted with your application, correct?
Well, yes, that was actually submitted as part of Dave's staff report.
And just for reference, it is noted as A21 for the record.
Upon submitting my application, there were objections that were received. But, just taking one step back, back when this application was being proposed, it wasn't under the current standards. However, I made attempts to speak with every possible user group that I thought there could be a conflict in. I've mentioned my attempts to speak with the Shell Fishermen's Association, but I went to the town. This was the application was publicly advertised by the town. It was part of a Harbor Commission meeting. I spoke with the harbor master at length at the time for the town of Barrington. I spoke about user conflicts. I spoke about what areas were used by shell fishermen, by water skiers, by kayakers, etc. That harbor master, after that conversation, he was given a copy of the exact site plan, and he agreed that there were no conflicts for this area. He sent me an email documenting his concurrence with this site.
And for reference purposes, that email has been submitted in with your application as well, and that was dated, an email dated November 19, 2016. I don't know if you can see it, but there's a copy here. It's kind of difficult to see. But that was also submitted with your application, correct?
Correct.
And if you don't mind, can you read that into the record?
Yeah, this is, so my email to the harbor master after discussing it said, Ray, attached are 2 maps of the proposed area outlined for the oyster farm. Mean low tide here is approximately 3 feet. Thank you for taking the time to look at it. My cell, I provided my cell number. for discussion. We had that discussion. And then the harbor master, Ray Souza, responded to me, and this site is okay with me, it's out of the way. And no moorings nearby, does get a lot of wave action, especially in the summer. Good luck, Ray Souza.
And did you also reached out to him again more recently, didn't you? Just to see if there were any changes in the activities by the harbor master?
I did, I reached out to the current harbor
Yes,
master,
you
who is
did.
not the same.
Okay. And you received a response from him as well?
I did, I submitted the same material from the original application to the current harbor master, Brian Hunt. And he responded, again, this was submitted as part of my application. Good afternoon, Ed. I've looked over the area shown in your chart and agree with the previous harbor master. I see no issues directly affecting any moorings in the proposed area. I do wish you luck in getting approval, as it seems like a great undertaking. Challenge will be wave action from both storms and boat traffic traversing the shipping channel. Thank you for reaching out.
And when was that dated?
That was on August 8th of this year.
Thank you.
So in addition to the harbor master, I spoke with, we had a preliminary determination meeting with both the town planner, the town manager, both of whom were enthusiastic about the application. That is also documented in the preliminary determination report. I consulted with Save the Bay, various groups that use that particular area, like sailfish, not sailfish, sailboarders, kayakers, etc. So I made attempts to contact and reach out to each of the groups that I thought might potentially weigh in on this application. So following that, I submitted my application. There were objections that were received that the council has a copy of. Most of those objections really fell into a category of objecting that this entire Upper Bay area should be set aside exclusively for co-harbors. And that this particular area, there was disagreement that it didn't have, that it had a low density. So in addition to Dave's personal sampling of that area, I went back and requested from DEM 20+ years of cohog survey data for that particular area. And as you'll be able to see, and can see in that packet, it has very specific grids where those density surveys were taken and the densities that were observed over 2 decades, going back to 1992 at the time. And yes, ma'am.
I just wanted to clarify. So you're talking about the DEM map studies, is that correct?
Yeah, so well, there's the density study is data, raw data, which the council has been supplied a copy of all of that data. And it also has a map that designates what each particular sampling square, where it is on the map. So my particular square it's 2-2. And a summary chart was, in addition to the raw data, was supplied to the council. And that summary chart averaged over 20 years, 0.47 cohogs per square meter. Again, far below the 3 cohogs per square meter that are relevant. And I don't recall which counselor brought up the question, but there is newer data. Although a particular site survey was not conducted by staff, there was a more recent density survey conducted in 2022, which there is a map of, again, submitted to the council for consideration. And that grid pattern showed for my particular grid a density, again, below 1 cohog per square meter.
So if I may, with that, it's going to be your, that was part of your application. That was exhibit 1B. that was submitted, is that correct?
That's correct.
That's the new study, and that's the Rhode Island Shellfish Management Plan Density Survey Plan dated in 2022.
Correct.
Thank you. Yeah. So. So in addition, you have looked at, can you actually just explain to the board how your, equipment is going to work, the actual setup of the equipment?
Sure. In order to both minimize the visual effect, staying away from floating gear, and also to mitigate the wave exposure in that area, because it does have southwest exposure. It's a suspended long line system, which has been in use for decades. It's suspended below the surface of the water, so it doesn't get the cresting waves that can really do a lot of damage to the equipment. The cages basically can rock back and forth on a line, so that allows them to absorb a lot of that wave action, as opposed to some of the more standard equipment, which are large cages that really absorb the impact of wave action. These cages just kind of swing on a line below the surface. And so, you know, those two particular characteristics were what led me to pick this particular type of equipment.
And just to clarify, it's going to be 2.5 acres, is that correct?
0.5 acres.
0.5 acres.
0.5 acres.
Half an acre. Thank you. Based on all your research of the area, the studies, the documents, the consultations reviewed, in your opinion, will your proposal have any significant adverse impact on the traditional fishery?
Well, no significant adverse impact. If anything, it would have a positive impact. As this council, I know, is aware of the positive effects of aquaculture, and specifically oyster aquaculture. Positive effects on water quality. You know, both DEM and CRMC have been involved with projects to seed oysters in the upper bay. And this is going to be essentially, these are diploid oysters, which means they breed, and they will release baby oysters into the water column, again serving repopulate oysters in the upper bay.
And you had there was a letter submitted by Mr. Robert Renault. Is that correct?
Robert Rowe, correct.
Robert Rowe. And that was submitted as part of your application, correct?
Correct.
And can you just briefly, do you have that exhibit?
I do.
And can you just give us this is the exhibit, I believe this was exhibit number 8 that was submitted to the council, is that correct?
I believe so.
Okay. And it is a letter that is dated on 9/1/23, is that correct?
Correct.
And can you just explain who Mr. Rowe is and where he's from and what the basis of his letter is?
Sure. So this council may be familiar with Mr. Rowe, as he has testified in front of the council before, but he is he has a doctorate from the University of Rhode Island. I believe it's in marine biology. He is essentially the godfather of aquaculture in Rhode Island. He had one of the very first leases in the state. He is president of the Ocean State Aquaculture Association, as well as the East Coast Shellfish Growers Association. And there's no one more knowledgeable in the state about these types of issues. And he was also part, as he documents in his letter, he was part of the original group that got together to discuss some of these issues, especially the issue of how to make a determination as to whether a particular area was commercially viable as a wild harvesting area, and coming up with that 3 quahog per square meter standard that is used. And as well as the 5% rule for the coastal ponds, and a lot of these kind of subsequent rules that have been relied upon in subsequent years.
And can you just read into the record his very last sentence of his opinion in his letter?
It is evident that this is not a site with commercially important densities of hard clams worthy of precluding aquaculture.
Thank you. Okay, we have nothing further. If there are any questions, Mr. Milano.
Any questions of Mrs. Troiano by the council? As well.
I had a question about your statement regarding the oysters improving the habitat and the ecosystem. Aside from the filtration point, you said that they also that the culture, the spat are gonna take off and live in the bay. What was the word that you used? I wasn't clear on what you said there.
Yeah, yes, ma'am, populate. So these are breeding oysters. Some of the oysters that are used are sterile, depending upon what type of seed you get. And so these would breed and release larvae out into the bay, which can then obviously settle into the bay and repopulate the oyster population in the upper bay.
So are these oysters native to Narragansett Bay?
So they are eastern oysters, which are the type that is native to the bay.
Eastern oysters are native to Narragansett Bay? So that's exactly the kind of oyster you're intending to breed?
Yes, ma'am, and that is documented in my application.
And so, with respect to the, relevance of that to other fisheries, how does that relate to, I understand you're not an expert in this and I'll just take it for what it's worth, but based on your testimony, what's the point of that? Whether they breed or not, whether they improve by creating more oysters, how is that relevant to the issues that have been raised that you've been testifying about with respect to the presence or abundance of other shellfish in the area? Does that have a negative impact on those shellfish? Does it have a positive impact on those shellfish? I'm just curious.
Yes, ma'am. So the relevant language, as far as I know, the relevant statutory language is the effect.
No, I mean ecological. I know what
Oh.
the statute says. I have it right in front of me.
Yeah, no, yes, so the ecological impact is there essentially are no hard shell clams there, but it will have a positive benefit ecologically in helping to revive the wild oyster population in the upper bay. Historically speaking, back in the late 1800s and 1900s, the upper bay of Rhode Island nationwide was the largest producer of oysters, with a net value of $600 million per year. That, due to natural disasters and the effects of pollution, was decimated in the early and mid 1900s. So, it's very important, and it's part of my reasons for establishing a farm in the upper bay, to help to restore that. It has as I've mentioned, has vast ecological effects, and documented effects to mitigate climate change and the effects of erosions. So if oyster reefs provide a natural barrier to storm surge, and that, currently we don't have a lot of that in the upper bay because the oyster population was decimated.
But that's not relevant to the application, right? Storm surge, you're not trying to build a barrier beach, or you're not trying to build a reef
No,
for storm
ma'am.
surge.
No,
You're just putting cages in on a line.
correct.
Okay, so that's not relevant. But it's informative. Thank you.
Any further questions of Mrs. Troiano?
Just,
Stay going, Wes.
yes, going through the previous documentation, you see that one of the reasons that there was a vote that disallowed the applicant the permission to establish this oyster farm was that the applicant did not establish that his application had a reasonable probability of causing detrimental impact on the coastal resources of the state. It seems that your testimony tonight tried to center on resolving that, and that in fact it would help that there is a reasonable probability that you will not cause detrimental impact to that area. And I went through some of the objectives. Somebody thought that his dog might get caught in the gear. They thought that the storms would wreck your gear, and there was recreational fishing in the area that would be in conflict. I think you addressed everything to my satisfaction, and maybe you want to comment on that reasonable probability of causing a detrimental impact, but you did not comment on the recreational fishing aspects, which I assume would be casting from the beach or something like that. Is that really prevalent in that area, or not? I'm not totally familiar.
So if we're talking about fin fishing,
Yes.
Mr. Gomez, yeah, so I have a center console boat, I fin fish a lot in that area. Now, you know, that particular area, as you can see from the application, is 2 to 3 feet of water. It's flat, it's like a sandbar. Fishing, you fish with structure, right? So rocks, changes in contour, etc. I have fished that area countless times over the past 25 years. There's no fish there. And that's evidenced by this application went to the Rhode Island Saltwater Anglers Association.
Okay.
And received no objection whatsoever.
Okay, that answers that question. And
There were 4 different members of RISA on the initial email that went out with a copy of the application, and there were no objections received.
it appears to me what you've done tonight is to try to attack the part of the rationale for not allowing your application to go forward, which is the reasonable probability of creating detrimental impact on the coastal environment. So I think all your statements would lead me to believe that it would not.
Any other questions? Okay. Any other witnesses or anything else at this point?
I'd just like to note that the stipulations that were read into the record earlier are acceptable to the applicant.
Yes.
Yes, Mr. Gatt.
I apologize. I'd like to clarify those stipulations. There were 2 additional ones that I did not get to after the discussion on conditional waters. So to recap, no expansion of the lease. Maintain 1.5 feet below mean low water to ensure the statements are submerged. Stipulations for the DEM Office of Water Resources on protocols for access and lease during closure. A $10,000 performance bond in the event of the gear does become dislodged and is not cleaned up or the lease is abandoned. And winter working hours for DEM Division of Fish and Wildlife. That can be found on attachment 19B of the original staff report, and either certain months and times of day to be restricted so as not to interfere with species such as black ducks and other foraging waterfowl.
And
that's it.
Thank you.
I just clarify, those additional stipulations are also acceptable. This would be approved.
Thank you.
Thank you.
Anyone else present this evening that wishes to speak in favor of this application? Anyone present this evening that wishes to speak in opposition of the application? I will start with the gentleman on this side right here, please.
Chairman, if I could,
Yes.
should we make it clear based on the remand that the attorney has the right to cross-examine any witnesses that come forward?
Yes, I think that that's appropriate, that an objector that comes before the council.
Oh, yes.
Oh, yes.
Oh, you just went, and then you remind them of that. They should present the amendment. Right? Yeah.
So will you please raise your right hand? Sir, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Will you state and spell your name for the record, please?
Michael Allen. That's one A, two A's and two L's. I spelled it wrong last time. McGivney, MC, big G, IVENEY.
Thank you, sir. And I just remind you that based on the remand from Superior Court, that the objector has the opportunity to question your testimony tonight.
Which is something I've never experienced in a public hearing. Thank you. I begin?
Yes, please.
Yes, my name is Michael McGivney Allen. I'm the president of the Round Shellfishing Association. Our association has been working on regulations and the shellfish, working for the shellfish industry since the 1980s. And we've been working on the aquaculture issues way back from the very beginning in the 1995 when the initial language was put forward. And we've pretty much reviewed every aquaculture lease that's been going forward through the Shellfish Advisory Panel. We worked with CRMC on mapping and making the aquaculture fit into areas that doesn't have any conflict. They mentioned the Eliason lease that happened early on in the late 90s, I believe. And it was actually that lease that caused us to go and talk to Dave Alves, who was the CRMC, the original Ben. And that's when we worked on the mapping, and we pointed out Rome Point as a suitable place for the aquaculture. And as most of you know, that has been a very productive area for them. This is the only lease that the only leases we've ever contested in front of the council were ones that were in the Upper Bay area. And that's because these grounds are so critical to our shellfishing industry. The Barrington Beach area in particular, I think you have a map there. That whole area in the wintertime is where we go to hide from the heavy northerly winds. You go and hug the shore and fish along there. I have a fisherman that showed up tonight that has been exclusively working along the shore. He lives over at Nyack Road. And if you wish, he can come up and explain how he's catching all along that shoreline. The way the shellfish work is they come and they set in certain areas and they move and they set in other areas. So you never really know where they're going to be. And frankly, when you do a survey 6 years ago, that doesn't really have much relevance to what's going on today. The area, I don't know if you're familiar, but the area to the north of this lease, which is area E, has seen a tremendous amount of shellfish set in that area. And because of water quality improvements, we have been able to get up there. Last year alone, we caught 10.5 million clams just north of this lease. It is our contention that as part of the evaluation of a lease, as how we evaluate it, and frankly, what Rob Rowe in the aquaculture letter was talking about is the density survey. And at the time, 6 years ago, it was very low. But it's easily could be double that. And according to my fisherman Alex, he said he's catching there. So these areas, you can't just take a snapshot. I know that's what some of you want to do, but these things change. And when I testified last 5 years ago, 6 years ago, I mentioned that we were working on a shellfish fan plan with Narragansett Bay, and we were hoping to protect some of these areas. And I think you got that on our packet, but
as part of that process, the CRMC has put a map together that they want to preclude leases in this entire area, anything that's a shellfish management area. And the reason it's a shellfish management area is because it's a lot of shellfish there. That's where the fishermen fish. It's also water quality related, but that's also part of the deal that it seems like the farther up the bay, the more clams there are, and it's more susceptible to closures. So this area that we're talking about used to close a 1/2 inch. I think it closes at 1.2 inches, but it still closes a considerable amount of time. And it was mentioned it'd be difficult for the leaseholder. We have not had a density study in 6 years. And I think that alone would kind of preclude us going forward, because that's been the way we've evaluated the leases over the years, is that basically the high density, low density would be allowable. But given the fact that it also is located in an area that is just historically critical to the shellfish industry, that is just so important and it needs to be done. So we do not oppose leases. We basically supported almost everyone, or not opposed everyone that's going forward. And I have a shellfish advisory panel, this was from 6 years ago, that they mentioned as part of the deal. Mr. Troiano is now on the shellfish advisory panel. He wasn't at this time. But you can see on the page that basically in the Troiano thing, it was basically the motion was made by me and to not support it because of the critical nature of it. And it was supported by the shellfish advisory panel 7-0 with 1 abstention. And that was the aquaculture representative. So even at that time, the aquaculture representative did not support it. He simply did not vote. And to show that we try to be fair on these things and we only concentrate on the areas that are really important to us, the next lease was Roebuck in Point Judith. And that was for 9 acres, I believe. And I made the motion to support that or not oppose it.
Attorney Sakarchi.
It's irrelevant to the current application, different application.
That house is gonna go.
Going into a piece
The applicant is able to provide objections and state the reasons for the objections thereof. And it'll be noted on the record and it'll be considered by the council now and later on.
So to my point, we've worked with the aquaculture industry. We've been part of the process for the last 30 years. And I think we've done a really good job making sure the leases that are currently in place there's very little conflict. And I believe that if this map was available that we asked for at the meeting back 5 years ago, that is currently now here, it would not be supported by CRMC. So things change, densities change, the mapping change, the amount of shellfish in the bay change. So I think these are all important aspects to it. Now, one point, I don't know if that's something that in the purview of the council, but the applicant is only asking for a 1/2 acre, and accordingly, he can never go beyond a 1/2 acre. I asked Ben here, what the average income for a 1/2 acre, for an acre in aquaculture. And he gave me the number of 18,000. That's the average what people make on aquaculture. When Dave Butel was involved, I asked him,
I'm just gonna make an objection that value is not part of the standard.
Yeah, well, you want to make a legal ruling on it?
Your objection is noted and on the record.
and I asked Mr. Butel, I hope this doesn't happen to the whole meeting, that what would a fully exploited lease, somebody that's got all their cages going, all their growing, what can they expect to make on something like that? And the number he gave me was $30,000 an acre. So you're probably talking, 15,000 potential. So without expansion, this is basically going to be a hobby farm. It's not really a financial, viable as we look at it.
Why is that relevant?
Because they're taking grounds away from people that need to make a living. That's how I make my living. I've been doing it for over 40 years. I've been working this area since the mid-80s when it opened. And take areas away for something that Frank, so that.
No, you answered it. You answered it. I know where you're coming from with that.
The council was correct when they denied the first time. The area is critical to the shellfish industry and goes against the CRMC mapping guidelines that have been since established. It has not had proper notification, which has now been changed to a new, much more robust to let everybody know. And the density studies for us would preclude us from even evaluating it. We don't know what's there. There is a standard. I mean, we work when we do that. If it's over 3, then we say no, and if it's under 3, we generally say yes, unless it's located in an area like this. And lastly, the enabling language for aquaculture, and this is what we worked on back in 95, 20-10-1, that says the process of aquaculture should only be conducted within the waters of the state in a manner consistent with the best public interest, with particular consideration given to the effect of aquaculture on other uses of the free and common fishery. So basically, that's kind of the guidance we look at what these leases should be. We support ones down at Rome Point, at Dutch Harbor, Fox Island, ponds, because they're not impeding on the free and common fishery. And we asked the council to do what the last council did and deny this lease. Thank you.
Thank you. Any cross-examination from the applicant?
Just one.
You want to have a question first? Mr. Gomez?
Yeah, it's my understanding that there are no other leases within what you consider as a protected area in the upper bay there. Is that correct in your?
No, and frankly, it's one of the reasons we met with CRMC. The Eliason lease was back when this area closed on a 1/2-inch rain. So when it opened, which was like 30% of the time, that's it. We'd all go to Barrington Beach because that was where it was good. And we didn't go there. Also, when this lease went through, none of the predetermination hearings, no sampling, nothing was involved, and it simply went right to public notice. So the lease went through in 45 days. Back then, the internet wasn't quite what it is, social networking, and we really felt like we dropped the ball when this lease went through. That is why I went to Dave Alves and said, listen, we can't have this happen again. And that's when we worked on the mapping, the original mapping, which as I mentioned before, identified Rome Point, which is now full to the point where there's so much activity there, and the areas above. So we worked with them after that because we understood the problem that this lease caused, and we didn't want to see another one there in that area.
Yeah, but is it correct that we do not have a SAMP for that area, the protected area, or not?
We do not have a special area management plan for that area.
Okay, thank you.
Back then you did, you do now.
We don't have a formally adopted special area management plan for that area. We have looked at developing what's called the base SAMP. We've gone through a number of management exercises to address issues within that area, primarily cable management and aquaculture. We have made a number of changes to our current regulatory environment based on those two efforts, but we haven't developed a fully robust special area management plan like we know them to exist today.
But you do have a chart on your website that precludes aquaculture in this area now.
Good job.
Any questions from the applicant of Mr. McGivney?
No, thank you.
All right, thank you.
Thank you very much.
Thank you. Who wishes to speak next? Come forward, sir.
Good evening, sir. Would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Would you please state and spell your name for the record?
David L. Gigliotti, Gigliotti.
Thank you, sir.
I won't take up much of your time. Listening to the previous beginnings of this proceeding, as I see it, you are kind of as it was, we're back in a time capsule of 2017, 2018 timeframe. And as Mr. McGivney had mentioned, and let me back up a little bit. I should introduce myself formally. I'm sorry, I apologize. My name is David Gigliotti. I'm the current Vice President of the Rhode Island Shell Fishermen's Association. Been a lifelong fisherman. I've been commercially fishing since the mid-80s. I currently am on the Shellfish Advisory Panel for the state of Rhode Island as well. And I oppose the lease. And now I'll explain why. In the beginning of this meeting, we were told that we couldn't introduce anything new. It had to basically go under the 2017 guidelines and rules, which, you know, it got me to thinking back when that first came across the Subcommittee's desk, so to speak, when we voted on that. And as Mr. McGivney had pointed out, it was 7-0. One of the things that I looked at in particular was how it affected the winter harvest. And in the winter, we notoriously get many northeast winds. And as commercial shell fishermen, we're a bit nomadic. We have to go where we can to make a day's pay. What that area is, what it really represents, is a safe haven for us. When you take a piece of that safe haven away, and I made mention of this back then, well, it gives us less, okay? And you're basically setting a precedent for others to follow suit. Right? If this lease goes through, there'll be more. With us in particular, because we have to fish according to conditions, whether it's wind and rain or rain closures and such, we don't fish there every day, no. But I can tell you that we were up there fishing 4 or 5 days ago when it blew hard out of the north. The fleet was up there. Now, for folks that work on land, that might not seem like a very big deal. But for those of us that work on the water, it's a huge deal, because that affords us a place that we can go and pay our electric bill. We can pay and buy groceries, okay? When I looked at the stipulations back in 2017 and I said, geez, a half an acre lease. I'm not gonna get wrapped up into the money end of it. But that's not a very big lease with no possibility of expansion. To that point, it seemed kind of like a hobby, to what Mr. McGivney was saying. So in essence, I'm looking at a gentleman that wants to come in, take away prime ground. And it is prime ground because in a northeast wind, we tuck right up into that corner and then we drift outward. Okay, we'll set our anchors for a hobby. Now, on top of that, I'm also a conch fisherman. And I set my gear through there in that depth of water, because when we fish for conch, especially in the fall run, they're coming out of the mud and they're going to the shallows because that's where they feed. They feed in those shallows and then they head back to the mud for hibernation. Now, I had spoken to 3 other comp fishermen just 2 days ago, and unfortunately, they could not make it here tonight. But they said, as well as myself, they set gear through that entire area. Now, I know that we can't really look at that because it's new data, but it really isn't new data. It's really old data. This has been going on for a long time. My biggest concern is the precedent it will set for future leases in A, conditional areas, and B, in areas that are most frequented by commercial shell fishermen, such as myself and the gentleman that sit behind me. We have seen an uptick this year in the amount of wild harvesters that have come back to the water. Significant uptick. And quite frankly, Area A is the most productive of those areas that we are afforded to fish. B, which is just south of that, is probably, well, there's a lot less down in B, okay? When there's a rain closure, we are in B, so it's heavily fished. A is where we know we can make, you know, a day's pay. And then further north of that, which is where Mr. McGivney was saying Area E or 16 is where the real money is at in the fishery right now, which is only, you know, half a mile away from this lease. I will say that I worked Barrington today, and there is a set in Barrington coming back. Beautiful set. I've talked to divers. The shorelines are setting up. Okay, now I don't know if this is part and parcel to us creating you know, kicking up the bottom up in Area E, and it's directly going down into that area, because if you look at the map on an outgoing tide, that outgoing tide goes directly into Barrington Beach. That's always been a good shellfish area, but I'm seeing more recruitment in that area. And in the next probably year or two, it's going to be a phenomenal set in that area. So again, getting back to my original statement, when I think about what it's moving forward, what it's going to do, it's actually going to open the door for other leases to come in. Okay, that's how I see it. That's how many fishermen see it. That size lease with oysters will not make a difference in water quality with the amount of water flow that runs from the Nyack down. It won't. It's too small. And if I was sitting on that side, I'd be asking myself one question, which none of you would ask Mr. Troiano. If he was so interested in leases, if he was so interested in doing aquaculture, why didn't he pick another place and revisit this? Why didn't he go and say, okay, I still want this lease, but why didn't he go to Rome Point or go further down? Why is it this lease? Because it's a lease of convenience.
Objection.
Yeah, I think, I mean, I can answer that. I mean, his testimony began with all the other places that he looked at. And his testimony was, he spoke to experts in the field. They pointed him here. So that's why he's looking
in the Upper Bay area, so.
for that area. And when we
But
had our
only in the
la-
Upper
wait,
Bay
wait,
area, sir.
But when we had our last hearing, he said, this is where I want it. It went to Superior Court and they sent it back and said, consider the application that he's asking for in this area. So that's what we have before. So he was not obligated to go look anywhere else.
Understood. But again,
Mr. Chair, I just want to give Attorney Chicarchi the opportunity to state the basis for her objection on the record.
Irrelevant.
Thank you, Attorney Chicarchi.
okay, well, again, it is the concern of not just myself, but the folks that I represent. And it's the folks that are not necessarily here tonight. And you're talking about an industry and many, many families that are impacted. So if you don't accept any new information into this, I want to give you one more piece of it, piece of what my thought process was that quahog sample that was taken in 2017 was not done by a professional shell fisherman. And that is in itself skewed. Because no disrespect to anybody in this room that pulls a bull rig, but you will not catch what a professional shell fisherman catches. You will not be able to cover that ground with as much efficiency as a professional shell fisherman. I was also on the state sampling team for CRMC, I believe. And I went through the process of getting calibrated by the state numerous times. I did some of the state sampling up in Area E. At best, dredge surveys are between 40 to 60%. At best. Bull rig, 99.3% in the hands of a professional shell fisherman. No disrespect to Mr. Butel or anybody doing that job now. But it's hard for a professional shell fisherman to actually believe that that is the density in that area. So with that being said, I thank you for your time and consideration. Again, I would like to put it on the record, I am opposed to this lease. And I hope that you uphold the initial decision that it was in 2017, or the initial outcome, I should say, that came out in 2017.
Thank you. Any questions of Mr. Gigliotti?
One quick question. Did that conch fishery exist in that area in 2017? Was it
Yes.
well used?
Yes. Yes.
Approximately how many conch fishermen do you think use that area? I know a lot of the lobster fishermen sometimes go for scup and.
That's a hard number. Well, that's kind of a hard number to pinpoint.
Well, it either gets used on a regular in 2017. Now, either got used on a regular basis or it didn't.
It was because again, that shoreline and any of those shallows get hit very hard when the fall run happens. It happens in the spring too, but in the fall run, it's particularly hard because they're getting ready to hibernate.
I got it.
But the horseshoe crabs go up into those low-lying areas to breed. So that the conch go after, the eggs and such and that kind of thing.
Thank you.
Okay, thanks.
Any questions of Mr. Gigliotti by the applicant?
Oh, no.
Okay. Thank you, sir.
Thank you.
Chairman.
Yes,
Can I ask a question of staff on the issue of setting a precedent, which Mr. Gugliotti brought up. And Jeff, you mentioned that we don't have a SAMP plan for that area, but we seem to be working toward having one. And apparently there's been guidance maps that have come out that were not out in 2017 that would sort of indicate that this is not an area that we want to encourage. So on the issue of setting a precedent, how long do you think it would take to have a SAM plan that might document that without predicting what the outcome of the plan will be? And would it be feasible in the interim, not related to this application, to have a moratorium until that is done?
It's a staffing and financial issue with the base SAMP. We had originally gotten some state funding for a base SAMP that almost immediately thereafter, the offshore wind industry and Revolution Wind in particular was looking to bring their export cable up through Narragansett Bay. And we had no mechanism to deal with that in the Red Book at that time. So the BASAMP as a whole special area management planning exercise was bifurcated to look at the cable management area. And then an aquaculture application over in the Succotash came up shortly thereafter. And that was in the 2018 timeframe when we looked at that. And then the opposition to an aquaculture application in the Succotash told us we need to focus on aquaculture and doing a better job in the notification and understanding of getting the public more involved in these decisions. So that, and under the umbrella of the BASAMP, we said, let's look at an aquaculture element. Those two efforts took up a lot of time, took all the financial resources that we had on the matter away. So we don't have the staffing nor financial capacity to bring in like a URI who usually helps us with these special area management plans. We need to start that again. We do ask for additional staff to address those types of management issues annually in our budget, and we'll do, it'll be part of the narrative request again to explain why we would need that type of staffing. So the long answer to your question is it'll take a little while longer once we have some staff that I can assign to that effort, because I don't have the capacity now to do it. And a moratorium, I don't see enough aquaculture applications in that part of the bay to support a moratorium, or enough aquaculture applications throughout anywhere in Narragansett Bay to support a moratorium.
Well, you can interpret that either way. So there's not that many applications and not too many people would be negatively affected by a moratorium.
Right, generally though, our moratoriums, and we did one when we did the Narrow River Special Area Management Plan back in the late 80s, because of the intensity of development that was occurring there. And we needed to get an understanding of what the impacts were of the river and groundwater in particular. I don't see a rush of aquaculture applications telling the agency we need to slow down and figure some things out.
I just wanted to follow up on the gentleman's comment.
Sure.
Which I think is a legitimate and reasonable comment.
Mm-hmm.
Anyone else wish to speak in opposition? Go forward, sir. Good evening.
Good evening, sir. Would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Will you please state and spell your name for the record?
Alex Caracuzo, C-A-R-A-C-U-Z-Z-O.
Thank you, sir.
Thank you. My name is Alex Caracuzo. I reside at 254 Nate Road in Barrington, very close to the applicant's aquaculture site. I moved there in 2017. Like the applicant, I've been an avid recreational fisherman my entire life since I was a small boy. I particularly am fond of quahogs. And while it wasn't the reason I moved to Barrington, I was very pleased when we moved across the street from the Barrington Beach area and discovered that quahogs were in abundance there. We have absolutely no problem finding quahogs with our feet, with a rake. We show people on the beach who live in the neighborhood and didn't realize that there's clams there, how to catch quahogs. It is just so easy. I regularly am out with my wife and my son in areas referencing back to the 2015 data. The 2017 data, with all due respect, is actually from 2015 from areas 2.1, 2.2, in the applicant's area 2.3, 2.4, and 2.5. And I've been in that area since 2017, and I can tell you on experience and belief that there's nobody who's been shore fishing that area as much as myself and my wife. Nobody. We're there all the time. So the density back in 2015, and that's over 8 years ago, that I'm seeing in the materials from the 2017 hearing is just nowhere close to what I'm experiencing. I'm literally able to walk out there, and within 10-15 minutes, I've got 3 or 4 dozen clamps for the day. And that's all up and down the shore. Now, the thing that I've experienced as you go from east to west on the shoreline, going from 2.5 to 2.1 through the 2.2 area, is that as you move toward Nate Point, toward the applicant's site, the quahogs are getting smaller and they're getting denser. And if you look at the old data from 2015, in the 2.4 zone, it's 7.7 quahogs per meter, and only in 2.2, there's 0 data. And I think that just shows you how erratic the dredging survey data can be. And I can tell you that I've had no problem up and down the shore finding quahogs. It's just that the further I get toward the site, they're getting smaller and more plentiful. So back in 2021, I was fortunate enough to get my commercial shellfish license, and I'm now a member of the Rhode Island Shellfishing Association. So, you know, being a bit inexperienced, and, you know, not the most proficient bull raker, but trying to find some proficient places to fish, I naturally chose an area that's adjacent to what I know, which is area 2.3, 2.2, and 2.1, right near my house where I've been shore raking for years. I'm adjacent to that spot every day, and let me tell you, it is great. There are sets of all sizes. I'm pulling out seed, little necks, top necks, quahogs, about equal proportions. The most encouraging piece is that I'm getting seed there. And, you know, the prevailing thought is that there's no seed in the bay. If there's no seed in area A, no, it's not true. That spot is, guys, don't take me out tomorrow, but this is, you know, I've been doing this, I've been in that spot for 3 years now. And I am just, I'm dreading the fact that there's gonna be perhaps some gear there that's gonna either stop my drift, stop us from going there in the winter. I mean, I don't know what those dredge surveys said 8 years ago and why we're putting stock in that right now, but I can tell you from personal experience, and again, you know, I get it. Recreational fishing is great. Moving to commercial shell fishing, whether it be quahogging, aquaculture, you know, I have the same goal. But that spot is just really good. And we would be doing a real disservice to the shell fishermen who are making a living here by taking that away based on 8-year-old data. And just to, you know, again, I'm not coming here with dredge data. It's not scientific. But just to tell you, like, I've been in area E on those bonanza days, and, you know, again, I'm not as efficient as Dave or Mike or some of the other more experienced guys behind me. I'm getting about 500 to 600 quahogs an hour there. I'm getting 250 to 300 in area A in that spot. So, I mean, you can do the math about what the density is based on that. And again, inefficient quahog are doing that. This is not a place you want to monkey with. This is where area A is going to come back, and it has already come back in those 8 years. So I don't know what else to say except, you know, this is I think it would be a disservice to the industry and the blue economy to try to just sweep, you know, under the rug the observances that you've heard tonight in the past 8 years. Thank you.
Thank you, sir. Any questions? Mr. Caracuzzo? Any questions by the applicant?
No.
No. Thank you. Thank you, sir. Anyone else wish to speak in opposition? Seeing none, I'll afford the applicant an opportunity for closing or
Yes,
any further evidence.
actually.
How are we doing? You good? Okay. That's it.
I may, Mr. Toronto, we heard some comments from the objectors. There was quite a bit of dialogue regarding the density of the quahogs, referring back to in 2017 density study. And then some reference that it had changed physically on site. You are aware that there is another density study, is that correct?
Correct.
Can you explain that to the board?
Density study was
Toward Park Street.
conducted by DEM in 2022, so last year. And that density showed for the exact same 2-2 strata that the previous gentleman referred to was less than 1 cohog per square meter. And we have the map that we can put up showing that exact data. That data and the consistency of the surveys has been the same from 2014 through 2022. Again, respectful of the previous testimony. I live in town. I'm on that same beach. I'm in there with my rig, testing from time to time. And where my particular site is, 600 feet offshore, there is not a thick density that you could sit in there for 10, 15, 20 minutes and not wake up a clam. So, and that's not just my opinion, that's 30 years worth of data. That area has never changed. You can see from these charts how DEM, not Ed Triano or the shell fisherman, has independently sampled this data.
I'm just blowing
It's
this.
a little hard because of the lighting.
Right.
Permission from the chairman to
Yes,
walk up to the
please.
screen.
Yeah. I can try to enlarge it too.
With these maps, again, this is not my map, this is DEM map. This was actually presented to the Shellfish Advisory Panel. Can you lower it, Marion? Please. Somehow. And I'm sorry, because we have to clarify, there is a lot of reference made in general to Barrington Beach and the Upper Bay. There are very productive areas of Barrington Beach, not Naya Point, Barrington Beach. Barrington Beach is, to Mike's point and Dave's point, been consistently a good producing area. I didn't choose to go to Barrington Beach. I choose this very specific area that I was directed to respectfully by other cohoggers. I mean, I know this group is here, but even other people in their own industry disagree with their point of view and directed me here. So this area here, you see this blue, those 2 blue dots there, while they look very small here, I have another map that I can show you. This represents approximately 100 acres of the bay, these 2 dots. And those dots, if the Mary can show the legend, which would be up top here, I'm sorry. So here's the legend. The blue dot is the lowest density measured by DEM. It's the absolute lowest density. It's below 1. Mine is right here. That's where my site is, as you can see. You're trying to confuse me.
Sorry, we're trying to. Yeah.
It's right here in this dot, and you can see where these gentlemen are talking about, where they're pulling out 10.5 million cohogs just last year. Right here, red, yellow. On one hand, we're saying the DEM surveys aren't reliable, but on the other hand, it's supporting exactly what they're telling you and what the harvest data says. 10.5 million right here in the red, in the orange, in the yellow, over here, this the green, 11 to 20 cohogs per square meter, all green, all in here. This is well off the shore. This is acres and acres away from where I am, and is where they're fishing. That's not where I put my application in, where they're fishing. I put it in this blue dot directed by shell fishermen because there's nothing there. And there hasn't been for 30 years. I have the utmost respect for these gentlemen. I sit on the Shellfish Advisory Panel with them. I vote the same way as them most of the time. My philosophical difference is that I don't agree that you can draw a line across the upper bay, which is roughly, hold on, right here, down to Prudence Island. It's 11,200 acres of the bay. Mayor, can you pull up the Google map that shows that? It's 11,200 acres. You can see from this and the other map, not every acre or half acre of that bay is productive. It's not just a blanket. Quahogs don't grow the same in every little square inch of the bay. And while I agree with them that there are very productive areas, consistently, you can see where they are. They're not where my lease is. I have not sought conflict with them. I actually sought them out to try and come to an understanding with them. But I can't come to an understanding with someone who won't even talk to me. And that's what happened in this case. And, you know, to the larger point of trying to cooperate, you heard testimony today about the winter harvest. I'll sit back down, I'm sorry. You can put that other map up, Mary, because I think it is relevant, because it shows the same consistency, the 2013 density survey. That's the 2022. That's the other one. Again, a survey done by DEM, not me, and the map by DEM. You see the same exact thing, and again, it's faint. Here's the blue, right here, off of Mayor Point, the blue over here, off of Rumstick, and then all the yellow and the red. All up in here, all out in here in the deeper water, well offshore. Those two surveys were done 2013 and 2022, 9 years apart. And they show the same data, and that same data is supported by the previous 20 years. Quahogs are just not growing in there. I'm not a marine biologist, I can't tell you why, but they don't grow there. But in the spirit, you know, listen, I sought to cooperate and to try and come to an agreement with the shell fishermen. I've heard that even though I don't think it is factually accurate that my particular lease area is a safe fishery in the winter time. I want to reach an agreement that would be agreeable to the shell fishermen. I will remove my gear in the winter time. I will put a stipulation into the lease agreement to remove all cages and lines from December 1st to March 15th so that they can go in there. They said it's a winter fishery, it's protected, they'll have free access. They can use it, they can take every quahog they can find off of that area. And I'm more than happy to do that. If that seems to be the principal objection, I'm happy to do that. You know, it always seems that these things tend to get adversarial. I don't think they need to be. I think that this can be a mutual agreement that can satisfy both parties. So I would stipulate to that. I mean, you know, again, I think that would hopefully for the council satisfy some of the concerns because it would give them the access. You know, I would know for the record that this is not a precedent. The council has approved that other lease, the Eliason lease. It's like it's directly across from where I am. It has been renewed twice by the council in 2010 and most recently in 2020. It's a bigger lease than mine substantially. It's 2.5 acres. It's in an area of much higher density, approaching that 3 quahogs per square meter. And it's much more accessible to the public because it's next to Connecticut Point Park. This is private, these are private residences in front of where I am. There's no access. You have to walk down all the way from Barrington Beach, like a half mile to get there. So, you know, there's no precedent here, and there's certainly no magnet effect. That lease has been there since 2020. There's been one other application besides mine in 20 years. And I apologize if I'm going on, but As you can tell, I'm passionate about the project. I do want to try and make it work. With these gentlemen, I'm certainly not trying to take away from their living, and there's nothing there to take away from their living. 10.5 million quahogs versus the 2 found on my half acre. Oh, and I guess the last thing, on the SAM, which I was a part of, that the purpose of that SAM, at least my understanding and from my listening in on it, was to sort out these exact issues. And while this topic was brought up, the only conclusion that came out of the SAM, which is in the letter that CRMC has on their website, the only substantial change that was recommended was a maximum of 2 acres for initial leases in the upper Narragansett Bay. Expansion after initial lease may be permitted to a maximum of 3 acres. That was the only recommendation that was in the SAM that was just conducted last year, specifically on aquaculture in the upper bay and siting of aquaculture. That members from all over the industry, including the shell fishermen, including academia, were involved in. That was the recommendation that was made. So this area was looked at, and obviously the conclusion was come to that there wasn't a significant change needed. I'm not asking for 2 acres. I'm asking for a half, 1/2 of an acre. Oh, the objections to or whelk fishermen. There is nothing in the record, absolutely no mention of conch. Not in the original application. There was no objection based on that. And furthermore, this went out to public notice 3 weeks ago. And there was no additional letters sent into the council, even mentioning conch. So I don't know where all the conch fishermen are, but obviously it wasn't something that they felt strongly enough to send in any comment.
I disagree.
Anything further?
I have nothing else for the council. I thank you very much for your time tonight.
Are there any questions of the applicant by the council? All right, thank you.
Thank you.
That concludes the testimony and evidence coming before the council. Is the council in a position to make a motion?
Yeah, I obviously pretty conflicted on this, and I had to keep thinking 2017. I just, based on notes that I took, and I appreciate the last comment on the conch fishery, but we're looking at a 1/2 acre farm, no expansion, 600 feet off shore. Then we're talking about a historically protected area for shellfish. And then we respond with Barrington Beach, lots, your area, none. So there's a little disagreement there. We do not have a SAM. I do not believe that allowing this lease will lead to similar applications, just by the fact that it has a lot of stipulations and it's a 1/2 acre in size. The conch fishery is something I'm very interested in, and it's a good fishery for people that are losing their lobster fishery and some of the other fisheries. But you have already commented on that. It was recommended by Dave Butel, who was in CRMC as an expert in this area for many, many years. The stipulations that were given at that time were very restrictive. You have agreed that you will remove the gear in the winter as a stipulation, if that's allowable or necessary. Approval of this would probably, in my opinion, set some precedents for other areas other than the upper bay where small farms are trying to be located. And so when I push all that together, I think at this point, for talking purposes, I would recommend, based on the findings of fact, our discussions here, the 2017 reports and data, that I would recommend approval of this oyster farm application with, as shown in the previous meeting, with those, for those stipulations and with the added stipulation that the gear will be removed in winter. So approval with the existing stipulations plus the one, and based on everything I've heard tonight.
Thank you. Is there a second?
I would second, just to clarify the motion, if I.
Yeah, sure.
Just on the final stipulation, just clarify it to say that the equipment would be removed between December 1st and
sure.
March 15th of each year.
Agreed.
Thank you. Any discussion?
Yes.
Yes, Ms. Wall.
So, this Superior Court decision guided this body to hear the public, members of the public, in fairness and to give reasonable faith and credit to all matters presented. Lay members of the public were subjected to objections by an attorney. A non-attorney on the council weighed in on the objection. Members of the public who are unrepresented, unable to rebut any objection or counter that. The council, under legal counsel's advice, held this hearing and under the guidance of the Superior Court as a contested case. I don't know how you can hear while you're speaking.
I can listen and hear you.
Really? Okay. Just as a matter
My
of
que- my
fairness on the
question-
record,
Just my question, maybe I can ask you, who's the non-attorney that you're referring to?
there's non-attorneys in the public being subjected to cross-examination by an attorney. They're not able to counter that objection.
I thought you said someone from the
So
council, a non-attorney from the council.
Non-attorney from the council.
Oh, I'm sorry, maybe I misunderstood. Okay.
And so it seems that we held this hearing based on the guidance given to us by the court, right, to have cross-examination. The court characterized this hearing going forward as a contested case. If in fact that's true, a contested hearing, what we held tonight was a hybrid hearing. A contested hearing in the interim period since this decision was rendered and these directives were given. The legislature has passed a statute that requires all contested hearings, contested cases to be heard by a hearing officer. In that scenario, we would be hearing the public in fairness. Members of the public, should they wish to be part of a contested hearing before a hearing officer, would have the opportunity to be on an equal footing. I think this process, this hybrid version, I think we lack authority to hear a contested case based on the legislation that was passed by the legislature requiring contested hearings to be heard by an administrative hearing officer. And so just procedurally, I don't think we have the authority to render a decision because I don't think we have the authority to sit as an administrative body when we have legislation that has directed that contested cases hearing officer. And just to the merits, our rules 1.2.1D3C, as cited by Dave Butel in the original report, state that we will consider aquaculture if I guess in the alternative, if we did have authority, I'll get to the merits, that there's no significant impacts on traditional fishery. And without any consideration at all of recent evidence, it's not clear that that's that traditional fishery is not suffering a significant impact. And I would say that it's not clear because this council didn't have the opportunity to hear from staff experts on those matters, nor did members of the public commenting on that issue sit at an equal footing when subjected to cross-examination by an attorney. And I understand that that was what was dictated, but our interpretation of that created a lack of clarity in the record. And I feel strongly that it's put an unfair burden both on the members of the public, on the applicant, on other users of this waterfront and these resources in the public that the council is bound to protect and represent, and also on the council in trying to make some kind of a fair decision here. So those are just my points.
Interest.
Absolutely.
Just as to our authority under this matter, our management procedures provide that a hearing can be before a subcommittee or thus the committee as a whole. So, and this application is supposed to be as it were in 2018.
But you stated earlier that it was a new hearing on old facts.
I don't think I said that.
I think what you said was that we are to consider, not to consider, to consider it a de novo hearing. I had suggested that the language was a de novo review of an application. Your advice was that it was a de novo hearing. And if that's the case, it's a contested hearing based on the characterization by the court. Our management procedures don't trump Rhode Island general laws, which just passed a statute saying contested cases should be heard by a hearing officer, administrative hearing officer.
Well, the question then becomes whether that statute has retroactive effect.
Retroactive if it was an old hearing, but I wonder about a new hearing, as you had described it, a de novo hearing. It's a new hearing. At least that's my understanding of what your directive was to us.
Yes, which the court assigned to the council.
I understand that's your point. My point's different, I guess.
So as I understand it, the court has said that because of a procedural error, unintentional, I assume I wasn't on the council then, for the original hearing in 2018, that the applicant was entitled to a new hearing based on the record that existed at that time. That's how I have heard it. Because other than that, then it would be a totally new hearing having nothing to do with the old application. So based on that, I mean, it's interesting to hear some of the new information, some of which conflicts with what the record was in 2017 and 2018, some of which does not, apparently. But I think the court has said the council made a mistake in how it conducted the hearing. To be honest with you, I've been in many hearings. I've never had a hearing like this where the applicant's attorney gets to cross-examine, but that does seem to be what the court said should have been done in 2018. That's new territory for me, but that's what the court is saying. Then it may become a precedent. So I think we have no choice as a body but to review the record as it existed at the time the applicant, according to the court, was denied their right to a fair hearing. And that's why it's back. And that's why we've had a motion and it's been seconded, so under discussion. I will vote to approve the application based on what I've read from the record and what I believe the court's guidance to be.
Given,
And
Just quick, the part of the motion was to add in an additional stipulation. From a legal standpoint, is that in keeping with what the court has asked us to do, that we could modify and add in another stipulation?
That's part of your authority on review.
Okay. Thank you.
Any further discussion?
I would just add that I was one of the members that voted no the first time around. I think this time around, we had to give consideration for cross-examination to people from the public that were making their case. So we did that. I didn't hear anything to change my mind in terms of how I voted the first time. I still think there are significant complications with the commercial fishery with this application, so I'm still in a position to not support it.
Any further discussion? Hearing none, I'll poll the council. The motion has been made and seconded to approve it with the enumerated stipulations. Ms. Hall?
No.
Mr. Gagnon?
No.
Mr. Flynn?
Yes.
Mr. Izzy?
Yes.
Mr. Gomez?
Aye, yes.
I too vote aye. Matter is approved 4-2. Thank you.
Thank you.
I don't think.
Having nothing else to come before the council, I'd entertain a motion to adjourn.
So.
Seconded, well, I don't have any discussion, all in favor, say aye.
Aye.
Meeting's adjourned. Me, whoever.
Yes. I'm glad we got some clear.